Okay, do I have Mr. Newman on the phone? Ms. Landreth?
Ms. Landreth is here, Your Honor. Thank you.
Mr. Furlong?
Here, yes, thank you.
Thank you. Then do I have Ms. Singh on the phone?
Yes, I'm here, Your Honor.
This isn't the court, this is the judge's clerk, but thank you.
Rebecca, would you like me just to go down the list and ask them to confirm that they're online? Because I can see who's participating.
And I don't have access to my computer for
Oh, I see. Would that be helpful?
That'd be helpful.
Okay. Can they hear me?
They can hear you.
Oh, okay, very good. Hello, everybody. Good afternoon. We are not on record yet. We just wanted to have a list of everybody who's on the phone, and we're just having a computer issue. So I can see, I think, who's with us, but I just want to confirm. So when I say your name, if you could just let me know that you can hear me and confirm that you're participating today. Ms. Harrison?
Here, Your Honor.
Okay. Ms. Walsh?
Yes, Your Honor, I'm here.
Okay. And is it Mr. Chaudhuri?
Ms. Chaudhuri, yes, Your Honor.
Oh, I'm sorry, Ms. Chaudhuri. Very good. And then I have just a phone number that ends in 515. I don't know who that is, but if you could speak up. A 907 something 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 515 number. All right, same question, but 732.
Your Honor, James Brooks here.
I'm sorry, James Brooks?
Yes.
Okay, thank you very much. And then there's somebody, it says Adhika, I believe. I don't know who that is, so if you could speak up and give us your full name.
Sure. This is Adhika Singh with the ACLU of Alaska.
With who, I'm sorry?
With the ACLU of Alaska.
ACLU, thank you so much. And
You're
then
welcome.
Beth Berg, I believe.
Hi, I'm here. Thank you.
Very good. And it's interesting because as people join, the list shuffles, so I have to make sure I've caught everybody. Let's see here.
Sorry to interrupt. I should mention one of those numbers is probably a recorded line from my station. I'm at home, but I believe we are recording telephonically from our station as well.
Okay, thank you. I appreciate that. Corey Mills?
Yes, I'm here, Your Honor. I'm with the Department of Law.
Thank you. And then Director Funumi, I have had problems with your name.
Yes, Your Honor, Gail Fanumi from Elections.
Thank you very much. And then is it Mr. Northrup?
Yes, Judge Guidi's law clerk.
Oh, so sorry. Hello, William. And then Becky Borer?
I'm here, thank you, from the Associated Press.
All right, thank you. And it looks like S. Kotef.
Yes, I'm here on behalf of plaintiffs.
Okay, thank you. Let me see who I've missed, and I'm sorry for this. Kevin Benedicto, I don't think I've said your name.
Yes, good afternoon, Your Honor. Kevin Benedicto from the Lawyers Committee.
Okay, thank you. And then Janelle Hafner.
Yes, Your Honor, I'm with the Department of Law.
All right, and is it, I see J.M. Grace, is that Joanne Grace?
It is, Your Honor, from the Department of Law.
All right, and Jay Ebenstein?
Yes, Your Honor. Good afternoon.
Good afternoon. And I'm just kind of going up this list one more time. Hold on one second. And again, it switches every time somebody comes on, so hopefully I have everybody. We already confirmed that Mr. Furlong is with us. And then MB, it says MB Bear, I think, MP Bear? Or Bar? MPBAHR? Is there anybody that's MPBAHR on the line? Okay. If I have missed anybody, please speak up, and if I have more than one person talking, we'll just kind of break it down and I'll get your names eventually. So have I forgotten anybody or failed to recognize anybody, rather?
Good afternoon, Your Honor. This is Joshua Decker with the ACLU of Alaska.
Okay, thank you.
And this is Natalie Landreth with the Native American Rights Fund.
Oh, thank you, Ms. Landreth. I know that Madam Clerk confirmed you were on there at the beginning, but I forgot to repeat it. Anybody else that I haven't acknowledged?
Hi, this is Natasha Bria from the Lawyers Committee for Civil Rights.
And your last name again, I'm so sorry.
Bria.
Oh, got it. Thank you so much. Anybody else? Okay, sorry about the delayed start. All right, we are here for oral argument on two motions, case motion number 1 and case motion number 3, and this is in Arctic Village Council versus Kevin Meyer et al. It's case number 3AN-20-07858. I think what we'll do is begin with case motion 3. In fact, I think I had communicated that through chambers to the parties. Case motion number 3 is the motion to dismiss. So we'll take argument on that first, and then we'll go to case motion number 1, which is the motion for preliminary injunction. We'll do that one second. Before we get started, I had one thing I wanted to talk with the parties about. Well, a couple of things, actually. First, let me ask for case motion number 3, which is the defendant's motion. Who will be arguing that?
I will, Your Honor. This is Lael Harrison.
Okay, Ms. Harrison? And Ms. Harrison, are you going to want to reserve any portion of your 20 minutes?
Yes, please, Your Honor. I'd like to reserve 5 minutes.
5 minutes. Okay, thank you. And who will be arguing on case motion number 3 for the plaintiffs?
I will be, Your Honor. This is Natalie Landreth from the Native American Rights Fund.
All right, thank you, Ms. Landreth. And then for case motion number 1, which is the plaintiff's motion for preliminary injunction, who will be arguing for the plaintiffs?
Same, Your Honor, Natalie Landreth for the plaintiffs.
Okay. And would you like to reserve time?
Yes, I would, please, Your Honor. 5 minutes for rebuttal.
All right. And who will be arguing for the defendants?
I will again, Your Honor. Lael Harrison.
Okay. Thank you. Next question. I received about an hour or so ago a letter pursuant to Alaska Rule of Civil Procedure 77L, and that rule provides that, or at least it strongly suggests that there should be or could be a response to such a filing. So I wanted to ask the defendants, and if I could ask you, Ms. Harrison, did you want to submit a response that is consistent and complies with 77L?
Yes, Your Honor. I believe we will submit something brief after this hearing. I believe there's at least one other development in one of those cases to add on to that.
Okay. Would it be too much to ask to have that filing by noon tomorrow?
Of course, that's fine.
Okay, sounds good. All right, thank you very much. Let me just get my chess clock out here, and I will time everybody. If I ask a lot of questions and I kind of take a lot of time away from your oral argument, I'll try to give you a little bit of extra time, but mostly we'll try to stick to the clock. Before we begin, Ms. Harrison and Ms. Landreth, I'll start with you, Ms. Landreth. Is there anything we need to discuss before we get started?
Not that I'm aware of, Your Honor. Thank you.
Okay, Ms. Harrison?
No, Your Honor. Thank you.
Okay. All right. When you're ready, Ms. Harrison.
Your Honor, I'd like to begin with a quote from the United States Supreme Court. It's a quote from Purcell v. Gonzalez. Court orders affecting elections, especially conflicting orders, can themselves result in voter confusion. and consequent incentive to remain away from the polls. As an election draws closer, that risk will increase. Now, the plaintiffs in this case are asking this court to order the Alaska Division of Elections to change course in the middle of an ongoing election cycle. This lawsuit was filed well after the primary election, just a few weeks before the REAA election, which happens next Tuesday, and less than 2 months before the general election. Now, there are similar lawsuits in other states challenging absentee ballot witnessing requirements in other states, and those lawsuits were filed months ago. Plaintiffs in some of those cases are affiliates of the League of Women Voters, one of the plaintiffs in this case. By waiting until early September after the primary election, this unreasonable delay has prejudiced the Division of Elections. Now, this court has already acknowledged that it is too late at this point for us to reprint or alter the absentee ballot materials. They need to go out on schedule. So the only remaining opportunity for relief for the plaintiffs at this late hour is a non-enforcement order and then some kind of a public education campaign about it. Right now, it's the 1st of October. The division is administering the REAA election. It will be certifying those results. It's putting together the general election pamphlet. It's translating those materials. It's making extraordinary efforts to recruit poll workers under these pandemic conditions and set up in-person voting in as safe an environment as is possible. The division has a lot on its hands at this point in time. And to add to that burden with a difficult public education campaign at this late date prejudices the division. And when I say a difficult public education campaign, what I mean is that the division would have to be fighting its own previous efforts to inform voters about the witnessing requirement. It would be swimming upstream against the material that it already put out and against what's written on the absentee ballot envelopes and against what it changing course from what it did in the primary election. So that's why it would be an exceptionally difficult public education campaign. So this court should find that this lawsuit was filed too late in the midst of an ongoing election cycle and dismiss the suit. I'd like to say something about procedure with dismissing the suit. This was all happening very quickly in a super expedited fashion. And we recognize that both parties, plaintiffs and defendants, relied on quite a bit of material outside of the pleadings. So this might be better framed at this point as a motion for summary judgment rather than a Rule 12 dismissal. And I apologize, we apologize for not recognizing that earlier. We do recognize it now. But it would still be appropriate under the summary judgment standard because there really are no disputes of material fact when it comes to the timing of these events. Much of the material that both sides are relying on is public information. No dispute about it. The timing of the elections, the timing of lawsuits in other cases, the timing of major events in the pandemic. And even, Your Honor, even the materials that each side has presented in its affidavits do not create a dispute of material fact. All affidavits, both the plaintiffs and the defendants, consistently show that both sides were very concerned about this pandemic and taking the pandemic seriously in the April, May, June timeframe when lawsuits were being filed in other states, including by other leagues of women voters. Now, the plaintiff's briefing suggests that, because Alaska case counts were lower in April and May, maybe it wouldn't have been reasonable for plaintiffs to sue at that time, that Alaska had dodged a bullet. This wasn't going to be a big issue in Alaska, but that's not what the affidavits show. And when you look at the actual evidence that's in the record before you, in fact, everyone is consistently saying, we were very concerned about this in April, in May, and June. The individual plaintiffs describe making efforts to avoid contact with others starting in late February and early March. Our village describes various levels of shutdown happening in April and May. Even the League of Women Voters describes their efforts to move their outreach activities from in-person events to remote or online events. So when you look at what's actually in the record, it doesn't appear that either the plaintiffs or the defendants were thinking in April and May that this wasn't going to be a big deal and that Alaska had dodged a bullet. That's not what's actually in the record. I'd also say on the procedural question, regardless of the summary judgment aspect of it and that standard, the strength of the defendant's laches defense is also relevant, Your Honor, in the context of your review of the motion for preliminary injunction, because of course, one of the standards on a motion for preliminary injunction is probable success on the merits. And if the plaintiffs, or excuse me, if the defendants have shown a strong laches defense, then that would go to the question of whether the plaintiffs are likely to succeed on the merits. So everything here is still relevant also in the context of whether the plaintiffs have shown probable success on the merits for preliminary injunction. Your Honor, I'd also like to talk about why laches is still relevant in light of your order denying the motion for a temporary restraining order. This late lawsuit would put the division in a position, if this court were to order the type of relief that it outlined in its order on the temporary restraining order, some kind of mass public education campaign. That puts the division in this very awkward situation of saying it's going to do one thing, doing one thing in the primary election, and then doing another, contradicting itself. There's one thing written on the absentee ballot envelopes, but we're actually doing something else. And that internal contradiction that the division would be forced into has really three problems the division's very concerned about. One is confusion. Another is the division's own credibility. And the final one is the big picture concern about public confidence in the electoral process. So let me talk about each of these. Confusion, this is of course the concern the US Supreme Court was talking about in Purcell v. Gonzalez. Confusion deters voting. We also, as discussed in the briefs, there's concern at the division that confusion could lead to inadvertent voter disenfranchisement, that other errors could be made in absentee voting based on confusion about what is and isn't required and how to go about it. The concern about credibility of the division, though, is a little bit different. And I think this is what the division is concerned about. They're concerned about voters saying to themselves, how do we know they won't change it back again later without telling us? How do we know they won't change something else at the last minute? If this part of the absentee ballot envelope is incorrect, how do I know about the rest of this? Right? Those are the types of credibility issues that would be raised by this late contradiction, this late change of course. I think
Harrison, I'm sorry to interrupt, but I wonder if that confusion that you are referring to, is it not possible to minimize confusion just by being very clear about the message, being very clear that nothing else is changing? And in fact, if there's confusion about whether or not the witness signature is required, doesn't the confusion kind of default to having a witness sign so there's really no harm? Sort of a two-part question there.
Sure. So first, in terms of the confusion, first of all, just to address the late date issue. I mean, airtime is really hard to get right now. We're really close to the general election, right? So stations are booked up with political messaging advertising already. There's not that much time to disseminate a message. So I think that the voters who actually do get the message, are likely to get an accurate message. The concern is the voters who get a garbled version of the message, who hear from a friend, who see something on social media that's maybe not accurate, who thought they heard something while they were cooking dinner on the radio but couldn't remember exactly what it was. I mean, those are the types of confusion concerns that are created by this, trying to do it so late in the process.
If somebody is speaking and they don't have their phone on mute, we need the phone on mute. There's some background noise. I'm sorry, Ms. Harrison, go ahead.
Sure. So I think that's the confusion that, the source of the confusion that we're worried about that is relevant to this latches issue in the late hour. But then you also ask, so what would be the bad effect of confusion? How could this lead to voter disenfranchisement? Here are some things, that we have sort of thought of already that we're worried about. One is somebody looks at this ballot envelope and thinks, I don't need to fill out any of this. That they don't get the message that it's just the witness signature and they don't fill out any of it. And then they haven't signed or provided an identifier and their ballot isn't counted. I think another concern that springs to mind is, the date of the ballot is within the box for the witness affidavit. So there's a concern that by waiving the witness signature, then people won't get the message that they also need to fill in the date on the ballot. And every year there are, occasionally some ballots that come in where the postmark is illegible or it didn't get postmarked at all, comes in after election day, and the division relies on the date on the ballot. So some might get not counted for that reason. But I think also there's just a lot of nervousness at the division about the things we haven't thought of yet, and the unintended consequences that it's so hard to predict how this would play out when we're trying to do it at such a late date. Does that answer your question, Your Honor?
It does. Thank you. I have sort of a follow-up question, and I hadn't thought this one through. But what if there was no sort of communication with the public about that? And I don't mean that in that they wouldn't know that this order had been issued if, in fact, I issued the order. But what if it was just a directive to the employees who are processing the ballots that you count ballots that are not witnessed? So people may return ballots, and they do, in fact, because you've included those statistics, people return ballots that are not signed. And if perhaps they just say to themselves, this year I'm not going to risk it, I'll return it, and the division will do what it does with it. And the division employees were directed to actually count those ballots. That wouldn't cause any confusion necessarily, would it, in terms of how the person treats their ballot?
Well, first, Your Honor, let me just note that I don't know that that's something that the plaintiffs are asking for. I don't know if that's something that the plaintiffs would consider relief to them in this case. So, but to follow your hypothetical through, I think the concern there is those second issues, is the credibility of the division and the confidence in the electoral process. Any kind of last minute change, especially a last minute change where you don't tell people, that has the potential, first of all, just to make voters think, how do I know they aren't going to change it later? How do I know I need to fill any of this out? Maybe they'll just waive it all later. Or, I don't want to vote at all absentee ballot because I don't know what they're going to do with it in the end. Remember last time they just changed it all at the last minute. So it leads to that kind of confusion and about, again, the credibility. Can we believe the materials that we're getting from the Division of Elections? And the Division of Elections works very hard to be accurate so that voters can be confident in the materials that they get from the division. But then let's also talk about the public confidence in the electoral process. I refer Your Honor again to the mission statement of the division. Our mission is to ensure public confidence in the electoral process by administering voter regulations and elections with the highest level of professional standards, integrity, security, accuracy, and fairness. So all of these goals are in aid of ensuring public confidence in the electoral process. And some kind of a last minute change, particularly if it's done without notifying voters.
Ms. Harrison, I'm so sorry to interrupt. It has been 15 minutes. I'm going to go ahead and toggle over, and then you'll have 5 minutes
That's fine.
when it's your turn again. Okay?
Thank you.
Okay, sorry to interrupt you. Thank you. All right, Ms. Landreth.
Thank you, Your Honor. And I appreciate the minute notice. I will set my own timer, and please interrupt me if I am over, of course.
Okay.
So thank you very much for hearing this case on an expedited schedule, as well as to my colleagues. I will be handling the argument for all plaintiffs, but I am on this case with a number of other attorneys, so I will pause maybe a moment or two before the end of my time because I can't confer at counsel table to make sure I haven't omitted anything before I sit down. So my office, Your Honor, is right across the street from the courts, as is defendants. We can both see it outside of our windows, but today we are awkwardly having court over the phone, something many of us would never have considered doing earlier this year. I can't imagine saying I'm not going to bother to walk across the street for a hearing, but here we are, and we all know why. We don't want to take the risk of being in the same room and possibly infecting each other, and we're able to do this because the court system changed the rules to protect us, and because this court allowed us to do this to protect us. That's what this case is about. Only Arctic Village, the members of the League of Women Voters, and Ms. Clark and Ms. Jones are asking for something far more important than the ability to attend court from the comfort of their homes. They're seeking to exercise the most fundamental right in a democracy, the right to vote, but they can't without taking significant risks of illness or even death. That's an enormous burden to bear, and to alleviate it, they have asked for modest adjustments. We'll talk about all of that, but first I want to address latches directly. Actually, first I should address the procedural issue. Rule 12 requires that for a motion for summary judgment that parties be able to respond to that. We would request that if the court is going to convert that we have the opportunity to respond to such a motion and include anything we think pertinent. Of course, there is a different legal standard there that we would have to address in briefing as well. So latches. The case, the defendants want this case measured by hindsight, but that's not the legal standard. It's an equitable defense, and I'm quoting here, available when a party delays asserting a claim for an unconscionable period, end quote. The defendant must establish two completely independent elements: that plaintiff unreasonably delayed in bringing in the action and that the unreasonable delay caused undue harm or prejudice. This is a fact-based inquiry taking into account, quote, the knowledge of plaintiffs, the conduct of defendants, the interest to be vindicated, and the resulting prejudice, end quote. And that's from the Moore case at page 16. And defendants bear the burden of establishing both elements of that defense, but they can't in this case. Now let's talk about the real timeline. This case was based on the challenges encountered around the August 18 primary. The defendants were notified by the plaintiffs on August 31st, only 13 days later. They responded on September 4th, and the case was filed just 4 days later on September 8th. Now, let's be honest, none of us imagined in March that we'd be here right now at home, working from home, homeschooling. Speaking of which, this situation is so fluid and unpredictable that this morning when I woke up, I thought my son was going back to elementary school on October 19th, and 30 minutes ago, we learned that he's not. Nobody could have predicted where we would be right now, except for potentially Dr. Fauci. That is not the timeline to analyze this case. The timeline is when plaintiffs knew for sure they had a problem, and that was around the primary. The plaintiffs, specifically Ms. Clark, Ms. Jones, and the vast majority of Arctic Village, had only ever voted in person. And defendants have the voter files, and they know this. They were not familiar with absentee ballots or the requirement for witness signatures. Their own voter records will show you these are in-person voters. Yet defendants want to charge them with knowledge of things they had never done and a pandemic that they had no idea where it would go. For laches to apply, plaintiffs would have had to know how the pandemic would develop back in March, April, or even May. They would have to know that in-person voting was not going to be an option 4, 5, or 6 months in the future, and also know that absentee ballots would require a witness signature, even though they had never voted absentee before. This makes no sense. This is not laches. Defendants suggest that plaintiffs should have sued in May or June, and they discussed this briefly here. But if we all recall, that's when Alaska's reopening was. We had about 35 active cases in May, and there was no reason to think that there's going to be no in-person voting at that time. That was our reopening time. That was when we were told. And so plaintiffs, quite frankly, didn't know they had a claim at that time, which leads us to the timing of this specific case. It was less than 3 weeks from injury to complaint, preliminary injunction, and motion to expedite. The case was filed almost 2 months before the election and a month before absentee ballots were publicly scheduled to go out. But through delays and schedule changes, defendants now claim that any change is impossible. The defendants first moved to change the judge, as is their right, and then they partially opposed the motion to expedite, delay number 1. Then instead of filing an opposition, they paired it with an improper motion to dismiss on a different schedule that plaintiffs could not respond to in less than 48 hours, creating delay number 2. All this time could have used to address relief of any kind, but it wasn't. This led to then moving the briefing deadline by 1 business day and then an additional 3 days delay in oral argument at defendants' requests. Plaintiffs would not have consented to hearing the motion to dismiss on this game schedule at all, and we might, possibly, not be having this piece of the arguments now if defendants had disclosed they were going to further compress the timeline by changing the publicly posted date to send out ballots. But they didn't. They posted on Twitter, and the words are, and I believe we've attached it to Mr. Furlong's affidavit, an exciting secret. Nobody knew that they were going to do this. So a lot of this timing is not due to any delay by defendants. I'm not aware of any case that says 3 weeks from injury to complaint is some undue laches. So we have to remember that plaintiffs filed a significant voting case in a matter of weeks. And through our original schedule, this case would have been ripe for decision about a week ago with oral argument. Without, it would have been ripe on the 18th. So let's talk about the second prong, that an unreasonable delay caused prejudice. And they spent some time in their opening talking about this. There is none to be seen, especially after this court's clarifying order. Defendants themselves have managed to make no fewer than 4 major changes in just the last 2 weeks that clearly undercut their argument that changes cannot be made now. On September 14th, the Division of Elections announced it had changed ballots for the general election to remove the independent and nonpartisan candidates' designations, and only those candidates, and also claimed it was too late to reprint. That's cited in our brief, Anchorage Daily News, Mr. James Brooks, 914 and 915. On September 21st, the Division of Elections was notified it had the wrong candidate listed for House District 35. They had to reprint and resend the ballots overseas. That's 921, also Mr. Brooks, Anchorage Daily News. On September 25th, Libertarian candidates sued on the same grounds as Elise Galvin had sued back on September 14th, that the ballots had removed his designation. This time the DOE said it wasn't too late to reprint and is now reprinting the ballots for the House district he is running in. That's MSN News, Cheyenne Matthews, author, September 26th. In addition, the state decided to reprint the ballots for 3 other House districts, for 11, 12, 16, and 38 to include the party affiliation of petition candidates. They're reprinting a total of 81,000 ballots due to the change of process that initiated on or around or were mailed on September 25th, just 6 days ago. And that's Microsoft News' Sean McGuire, September 28th. This list is proof that changes can be and are made now if defendants want to make them. And they can find the time if they want to. Now, this is particularly important in light of what we're limited to requesting now, and so I'll discuss that. We never asked for the absentee ballots to be reprinted. The plaintiffs were looking for some alternative to let people know. And the court has already identified one of the issues here, which is that the confusion is really a non-issue. Because if we work that out to its natural conclusion, someone is confused and they think they need a witness signature when they don't, the ballot is counted. They're confused and they don't sign it for some other reason, like the 456 people in August, it still counts. So there's really no harm to the confusion. And as for the credibility or other issues that were brought up, these are all completely speculative. There's no evidence, there's no nothing Purcell is nothing more than a quote from a federal case interpreting the federal constitution that has nothing to do with Alaska law. There really isn't anything other than speculation, including, as Ms. Harrison just mentioned, things they haven't thought of, quote unquote. That's not the basis on which to dismiss a voting case based on latches.
Ms. Landreth, can I interrupt you and ask a question?
Of course, Your Honor.
Thank you. I think that it's kind of important to understand what specific relief the plaintiffs would be asking for if they prevail on their motion for preliminary injunction, because that, I think, informs whether or not there's undue prejudice with respect to the latches argument. I don't know if you're tracking that so far, if it makes sense.
Sure, I'm more than happy to answer that. That's a critical point, because in our complaint, not only had we never asked for ballots to be reprinted, and I'm sorry I said we, I mean the plaintiffs, it was left open-ended, some mechanism to inform the voters to allow for the division to have the most efficient or most effective method. We had suggested prior to the court's decision, you've got to have an insert or something in real time. That would have been ideal. But if the director says that's impossible and the court says that's impossible, we move to other options, of which there are many. All of these changes that I've discussed in recent weeks, all of these things can be handled by, they can post it on their Twitter account. How about an announcement on the Division of Elections webpage? A few public service advertisements. Ideally, it would be great to send a postcard the way they do in voter purges to anyone who's requested an absentee ballot to tell them that. And we need them to respond to talk about the feasibility of doing that. My point is that that's the only component we're discussing here. The two others, the court has already mentioned, count the unsigned ballots, signed and unsigned, and train and just tell the people that are counting the ballots to make sure they're counted. Those things there has been really no dispute about because it's in the future. The question is, how can we tell voters? And in order for it to be fair to everybody who is situated like our voters, there really should be a public announcement of some variety. And we at plaintiffs, at League of Women Voters, at whoever, will all share that announcement as well to help ensure that it's as broadly distributed as possible. So I think that's a key point. And our answer is we're extremely flexible, but we want you to make some effort to tell people so that if people can do this and don't have to take this personal risk, that that's not just available to Ms. Clark and Ms. Jones and the people in Arctic Village, that other people also have that choice. Does that answer your question, or are there further things you'd like to ask me about relief?
No, that does answer my question. I don't know if there's any other type of relief that you haven't mentioned that is something that you think is something to be considered. And if so, this would be the time to raise it, because I do think it kind of dovetails with the prejudice argument.
Sure. Well, I think those are our three major components. Train your ballot counters to count them so that the 456 people from August are not, or the ones like them are not rejected, and then actually count them, which is an event 3 or 4 weeks in advance. Those are the two main pieces. And third is to find some mechanism to let voters know. And we left that open-ended, the complaint, to allow for that piece. But that's really it, Your Honor. And that's why we don't understand why the state of Alaska doesn't want to do this. We don't understand, especially when just 60 days ago, they were making their own decision to change the longstanding rule about having to request an absentee ballot and mail those to voters over the age of 65. Yes, great decision, but it's those same people that then have to go get a witness signature. So there's one last thing.
You have just about a minute left, Ms. Landreth.
Oh, sure. So the last thing I want to say is laches has not been applied against an individual voter in a right to vote case. It hasn't. This would be the first. It's applied to ballot measure cases occasionally and other issues, but it has never been used by the state of Alaska against its voters to prevent them from changing a right to vote issue. This is not the time to be the first case. Thank you, Your Honor.
Thank you so much. All right, Ms. Harrison, 5 more minutes. I do have one question for you, if you don't mind me leading with it.
That would be fine. Thank you.
Okay, here's my question. And if this was in the briefing, I missed it. In terms of the absentee ballot application, it's my understanding that a voter can ask for the absentee ballot to be delivered by electronic means. Am I correct so far?
That's correct.
Okay, and roughly about the time that the briefing was submitted, there were about 95,000 applications for absentee ballots. Is that correct too?
That's at the time that the most recent briefing on the TRO, so just the other day, that was correct, yes.
All right. Do you happen to know, out of that number of absentee ballot applications, how many people want to have the ballot delivered by electronic means?
I do not know, Your Honor, I'm sorry.
The reason I asked that question, it seems like it would be a very direct way to communicate the suspension of the witness requirement, if that's the way the court goes, by sending an email to somebody who's comfortable enough to receive their ballot materials by email. So my thought was, if half of the applications asked for delivery by electronic means, which I would doubt, but if they did, that's a very direct mechanism that isn't necessarily susceptible to confusion, or at least not as much. That's just something I was wondering about. So if you don't know the answer, that's okay, and go ahead and take a few minutes to finish up. Thank you.
All right, thank you, Your Honor. Just to respond to the plaintiffs, I think the point I want to make here is this case was not brought late by a matter of days. It was brought late by a matter of months. So the question of when the briefing schedule, when the this or when the that, the arguments would have been the same on any schedule proposed. The few days did not make the difference. I thought it very interesting that plaintiff's counsel said, none of us imagined in March, but the division imagined. The division, according to Ms. Fanumiai's affidavit, was preparing for this increase in absentee balloting in May, sending large orders to the printer in early June. Plaintiff's counsel mentioned the mailing to folks over 65. I believe that decision was made in May and also sent to the printer in June. So the division was preparing at this time. And leagues of women voters in other states were bringing lawsuits at this time. And I would also say, with regards to notice of the requirement, perhaps the individual plaintiffs didn't know about the witnessing requirement until they received their absentee ballot materials for the primary. But the League of Women Voters of Alaska is a voter education and outreach organization who cannot credibly claim to have found out about this for the first time at the beginning of this primary election. Surely this is something they've been aware of for a long time and educated voters about traditionally. I'd like to go back, conclude with the point that I was starting to make in response to your question earlier, Your Honor, which is about the mission of the division and voter and public confidence in the electoral process. Your Honor, some of the news articles were cited in the briefing. I expect you're aware there is a national climate of suspicion about how the absentee ballot process works already. And I think the division is very concerned that a last-minute change to something which is an anti-fraud provision, especially if it's done without telling people, could feed those doubts. So I would ask Your Honor to consider that mission of ensuring public confidence in the electoral process as a vital part of the division's mission and concerns about any last-minute change, especially if it has the potential to not be provided, the information not provided to voters, to a last-minute change that's different from what we did in the primary, or to a last-minute change at this stage in an ongoing election cycle. Thank you, Your Honor.
Thank you so much. And to be clear, if there was this change, this suspension, of course, the voters are entitled to know that. It's a matter of how you communicate it in a way that's least susceptible, I think, to confusion, and that may be limiting the way that you communicate it. I don't know. I haven't thought that through, but my point is, you were saying that there is this great risk for confusion, and one way possibly to address that is to be very careful about which mechanisms you use to communicate it and how it's communicated. So that I just wanted to point that out. All right.
I have received the information about electronic transmission ballots.
Oh, thank you. Okay, thanks.
It appears that 5,800.
Oh, I'm sorry, can you say it again?
5,800, so a very small subset of the 95,000. 5,800.
Related question, even if you don't request a ballot, an absentee ballot by electronic means, do voters provide their email address and are they maintained in a database if you are requesting an absentee ballot? Is that something that's just in the profile, for lack of a better way of putting it? Do you happen to know the answer to that?
I do not, Your Honor.
Okay, thank you so much. I really appreciate the arguments on the motion. All right, why don't we go ahead and switch gears and go to case motion number 1. And I'm going to reset my clock here, so give me a second. And this motion, of course, was filed by the plaintiff, so we will have Ms. Landreth begin. Are you ready, Ms. Landreth?
I am. Thank you, Your Honor.
Okay, go ahead.
Thank you. The plaintiffs in this case just want to be able to vote without risking their health or their lives. And the pandemic, no one's fault, has taken away what used to be normal. They used to vote in person, but they can't do that anymore. The harm to them is twofold. First is the choice that is being forced on them in the electorate, which they describe as a devastating choice in their affidavits, and actual disenfranchisement, which is in the League of Women Voters affidavit. So they've asked for simple things, which we've already discussed here. Count the ballots, make sure your ballot counters know to count them, and find some mechanism to tell voters so that they're not deterred from voting by this requirement. And so they all have a fair chance to take advantage of any change. And that's it. It was deliberately left open to find the way most accommodating, the easiest, and effective. The plaintiffs brought 2 claims, both under the Alaska Constitution, the first for a violation of the right to vote, and the second is for a violation of equal rights. As part of the preliminary injunction, I'll go through analysis of the probable success on the merits of each, but first let's look at the applicable standard for a preliminary injunction. The Alaska Supreme Court has said the showing required for a preliminary injunction depends on the nature of the threatened injury. Number 1, where the injury threatened is irreparable and the opposing party is adequately protected, you balance the hardships, and that's Metcalf. And 2, otherwise clear showing of probable success on the merits. And we've provided a lot of these citations in our brief already. The first standard, the irreparable injury and the opposing party being adequately protected, is what applies here, but plaintiffs meet both, so I'm going to go over both. First, the Metcalf Standard 1. The plaintiff's hardships burden is extreme. Many federal courts have noted that the loss of a vote is irreparable, including this year under the exact same circumstances. Some of them say, quote, there can be no more injury more irreparable than the loss of life, the risk of serious lasting illness or death. And that's from one of the cases in our brief called Thacker versus Dahl. But really, there is no remedy for losing your vote either. Once the election passes, that itself is also irreparable. It is a terrible, unacceptable, and unnecessary choice.
Ms. Landreth, I'm hoping you can educate me on your view of the application of this particular test, the balance of the hardships. And as I read it, in order to succeed on the balance of the hardships, the moving party has to show that they'll suffer certain and irreparable harm. And you're talking about that. I understand that. What I'm trying to understand is what exactly is the certain and irreparable harm here. And I'll tell you what I'm confused about, and you can help me understand better. So, for example, with the individual plaintiffs, I read their affidavits, and unless I'm mistaken, what they said is they don't want to be forced into that corner. They don't want to have to make that choice. But they don't say they won't vote. They say that they don't want to have to make that decision. So how can the court say that there will be certain harm to them in terms of losing the right to vote if they have not made that decision? Does that question make sense to you?
It does, Your Honor, and I think the answer to that question might depend on the outcome of this case. It also depends on some of the issues that we discussed in the first part of this hearing where you don't exactly know what's going to happen in the pandemic. If numbers are really high and people feel like I'm not going to take that risk. You know, for example, Anchorage having its record case highs last week, Ms. Clark might decide, I can't do this. And that's the nature of the unpredictability of the pandemic combined with the unnecessary aspect of the choice. They haven't said yet that they're going to vote and do the same thing they did in August. They haven't.
No, they have not. And I think my problem is, yes, let's say things change and it gets worse. And then they make the decision, I'm certainly not going to subject myself to, a witness. I'm not going to risk my health, that sort of thing. That's a decision made after I have the information before me to make a decision now. So I'm just trying to figure out what is certain at this point. And again, I understand your argument. I do. I'm just trying to figure out with that standard, can it be met here?
Sure, Your Honor. And the certainty is the harm of being forced to make that choice, which is not something you should have to do when you ordinarily go vote, and not something any of us have ever had to do before. That's part of the harm. But the other is in the League of Women Voters affidavit, where they describe the disenfranchisement of voters who can't do this. But I think at this point, plaintiffs can't be held to a standard of saying they will or won't if they don't know whether or not the witness requirement is going to be there, and they don't know whether or not the case counts or anything is going to be closed. If the neighbor Ms. Clark relied on is not there, we know Ms. Jones can't vote in the way that she did in August because the Postal Service is no longer allowed to witness ballots. But of course, if we waited until we knew that choice, we would be in the predicament from the first half of the case where they say, oh, now it's too late for us to do anything to help you. And so they're in this quandary. And so the harm is forcing that on the electorate, making them choose in the first place. But we know that there were also, according to League of Women Voters affidavit, some disenfranchising aspects of that harm. For Arctic Village in particular, still under this, they have to break quarantine if they're going to go converse with somebody else. So they have to break the law in the village and place themselves at risk. So make no mistake, this is an extremely high risk activity for plaintiffs, and we can't understate that. Alaska Natives are 14% of the population, but 43 as of today % of fatalities. They are 2.5 to 3 times more likely to die from COVID. And so this choice being put upon them is not one that can be taken lightly. This choice is truly harmful and burdensome, and not one that we have fortunately ever had to associate before with voting. And that's why we say the choice is the harm, because nobody should have to say, what if I get sick? I don't know if my neighbor across the street has been to a restaurant. I don't know if their kids are going to preschool, but I need somebody to witness my ballot, so I have to do something. Why are we doing that to voters? And the answer is we shouldn't be, because it hurts them. That's a real harm.
And for Arctic Village Council, would it be fair to say that for them, I guess, the choice would have to be made to break the quarantine or the lockdown for the village and basically have the witnessing, having somebody available to serve in the capacity to fulfill the witness requirement, and that would put the council in the position of putting its entire community at risk?
That's exactly right, because can you imagine something worse really than the same person going to everybody's door over and over and over again? That person has now been in contact with every house in the village. And so they're going against the rules that they have set. And I want to point out as well, how many people are we talking about? It's quite a few. According to the census data cited in our opening brief, 1/4 of Alaskans live alone, 25.7%. Arctic Village said it's about 50% of its residents. They have a higher population in the summer, but right now it's about 100. 50 of those people live alone with no one over 18. And so they have to break quarantine. They have to break their own rules and the things that they have put in place in order to get those people to vote. And we also know that, of course, 456 were rejected in August for witness signature issues. That's either someone not getting a signature or signing for themselves, which I have to admit, I think I might have actually done in 2004 or 2006 and had my ballot rejected. And so there is real harm that occurred both in that primary from those issues, the harm of the choice, the harm of the council breaking its own rules, and the risks that people are being forced to create. But on the flip side, the state is adequately protected here. And I say that because there is no proof, nothing more than vague assertions that a witness signature has ever played a role in discovering fraud. According to the Heritage Foundation, there have only ever been 3 cases of voter fraud in Alaska out of millions and millions and millions of votes. None involved a witness signature, not even the recent one cited by defendants in their briefing. That was, of course, their signature match. The absentee ballot already requires, if you look at what's been provided in the opposition to our motion for a preliminary injunction, you will see there's instructions there and what you have to put on the outside of the envelope. And you have to put a voter ID, like driver's license, last 4 of your social security number, and a signature under penalty of law. And then the division also has these voter signature files that they use to compare and have successfully already used to discover in the case that they cite in their opposition. They haven't shown how they aren't adequately protected, other than these, vague parade of horribles that can't be predicted or tended to unless we know what they are. So on balance, plaintiffs have established that they face irreparable harm, not only through the choice, but through the very likely loss of a vote based on circumstances that they can't predict, but some of which are known, including being forced to break quarantine and create a risk to yourself. But the state is adequately protected. Let's look at the Metcalfe second standard, the alternative probable success on the merits. And the Alaska Supreme Court articulated the test to evaluate burdens on constitutionally protected rights like voting. And that's from Green in 2005. And it's, quote, "As the burden becomes more severe, the government interest must be more compelling and fit the challenge legislation, and the state's interest must be closer," end quote. And Alaska, of course, accords broader protections to the right to vote than the federal constitution. And we've cited some of those on pages 28 and 29 of our motion. And Metcalfe, of course, says the same thing. And this right to vote must receive strict scrutiny. We know ballot access and equal protection cases receive strict scrutiny. It would be amazing and totally unprecedented to hold that the fundamental individual right to vote somehow gets lesser scrutiny. So one of the arguments defendants have made about this is that this statute is older and didn't suddenly become unconstitutional. But plaintiffs did not bring a facial challenge for that reason. That's not the purpose of this. It is entirely given the unprecedented situation we find ourselves in, the very high death rates, the absolute need to vote by an absentee ballot that has created this severe burden. And so some of the cases that we have identified show that this court is not alone right now. Some of the additional cases from yesterday where plaintiffs in other states are doing the same thing as we speak because they are placing themselves in the exact same position. And I won't go through all of those because they're available to the court as well. But one interesting thing to note from People First of Alabama, which is the I won't read the full civil action number. People First of Alabama versus Merrill provided to the court today. And the court notes on page 2, the plaintiffs contend that forcing voters to bear that risk runs afoul of their fundamental right to vote and violates federal law. And they seek an order barring the defendants from enforcing it just for the general election in November. And without this relief, the plaintiffs believe voters will face an impossible choice between jeopardizing their health or sacrificing their right to vote in a pandemic. And of course, the state of Alabama's response was the same as here. The defendants maintain, and I'm quoting again, this is page 4 of that opinion, that the challenge provisions are necessary to preserve the legitimacy of the general election by preventing voter fraud and safeguarding voter confidence. And the court ultimately found that these challenged provisions, the witness signature requirement, quote, only marginally advance the state's interest while significantly burdening the right to vote. And the reason I read all that, Your Honor, is that I couldn't have said it better myself. And the court made it really clear, looking at its declaration in order, declaration number 1. It's not a facial challenge. It doesn't strike it down. It starts off with, as applied during the COVID-19 pandemic. And that's exactly what we're asking for. Because here the burden on
Ms. Landris, I'm sorry to jump in. I just want to be sure I'm understanding the relief that you're that your clients are seeking, that the plaintiffs are seeking. It caught my eye on page 4 of your motion, where you indicated that you wanted the court to enjoin defendants from enforcing the witness requirement in the November 3rd, 2020 general election and in all elections held during the COVID-19 pandemic. Is it fair to say that you're scaling back on that and you're really just asking for relief with respect to the upcoming general election?
Yes, Your Honor, that is fair to say. I think we put that in there based on the defendant's arguments in latches and are trying to be protective of future issues. But I think it's fair to say that that would be sufficient relief in this case. I hope, for goodness sakes, that when it comes around to the odd year election next year, we are not in the same situation.
Just wanted to double check. Thank you so much.
Thank you, Your Honor.
You have about 30 seconds left on your 15 minutes.
Thank you, Your Honor. So the last few points that I want to say is the state really doesn't have a countervailing interest. We've discussed how voter fraud is an illusory concern, 3 cases out of millions of votes. And if the state's interest is in protecting voter confidence, it's very likely to inspire voter confidence that voters will get the message that the state wants them to vote. It's making it easier for them and is caring for their health and safety during a pandemic. So there shouldn't be confusion about this law, which is a topic relevant to the first half. And of course, it's also relevant here because it's part of the same defense, because it's the Division of Elections that's charged with informing the public, and it can be done in a very simple and clear manner. And with that, Your Honor, I believe my time is up.
Thank you very much. I appreciate it. All right, Ms. Harrison.
Yes, Your Honor. If I could just have a moment to organize my notes.
Absolutely. That would be great. And I have a couple of questions for you right out of the box, so let me know when you're ready. And I'll pause here. Oh, did you say you're ready?
Yes, I am, Your Honor. Would you like to just begin with your questions?
Sure, I have a couple for you. You know, my first question, and I think I know the answer, I don't get the impression at all that the defendants are arguing that the plaintiffs don't have standing to bring this suit. I think standing is not at issue. I just want to get that out of the way. Is that fair to say?
Yes, that is, Your Honor.
All right. And I did want to talk very briefly about the statistics that Ms. Landreth referenced a few minutes ago. And they're startling statistics. And as she indicated, at least from my notes from the briefing, for Alaska, Indigenous people make up 15.6% of the population, but 43% of the deaths from COVID-19, and that was as of the briefing in terms of when that was submitted. And they provided statistics from other states that were even more troubling, if that's possible. Your briefing, the defendant's briefing stated that the current statistical data suggests that Alaska Natives may be at a somewhat increased risk of hospitalization or death from the disease than individuals of other races. My question for you is, do you object to the court accepting as true, generally, that that Alaska Natives as a population are more susceptible to COVID-19?
Your Honor, first let me explain at least my understanding of the difference between the statistics that the division is looking at and the statistics that the plaintiffs are looking at.
Okay.
My understanding is the division is looking at the statistics from the Department of Health and Social Services. And that tracks, as you'll see, the website is cited, that tracks race, known and unknown. And we believe the most accurate statistic to use in this context is known race as a percentage of all hospitalizations, as a percentage of all deaths. My understanding is the website that the plaintiffs are looking at removes any case in which race is unknown and only then looks at what percentage of known race cases are Native American, American Indian versus all those known race cases. So when you add back in the cases where the race is unknown, it changes the statistic fairly significantly, and that's why those statistics look different. In terms of what is the state willing to say about that, my understanding is, this is statistical data. There haven't been rigorous studies. There haven't been, peer-reviewed, any kind of analysis of this data beyond what we're seeing, on a day-to-day basis as the numbers change. So what conclusions we can draw from that data, I don't know that there's been any scientific analysis of that. We can just tell you what we're seeing on the ground right now.
All right, thank you. Another question. When we look at the balance of the hardships test, one prong is that the plaintiffs must raise serious and substantial questions going to the merits of the case. Do you disagree that that prong is met in terms of that particular test or standard?
Your Honor, it's a difficult one. I think if it weren't for the laches defense, I would feel more comfortable agreeing with that. But we do feel that the laches defense is so strong in this situation that it renders the rest of the merits issues less weighty, because we believe that the defendants are so likely to succeed on their laches defense. So I would say no, it based strongly on the strength of the laches defense at this point.
So if they had filed this lawsuit back in May, raising the same arguments at that point, would you disagree that they were raising serious and substantial questions going to the merits of the case?
It's hard to speculate, but I think likely so. This lawsuit would have looked very different if it had been filed in May, and the arguments that everyone would have been making would have looked very different back in May. Something that I think is very difficult about the late date of this lawsuit is what's just been discussed between you and plaintiff's counsel about what is the relief. And I think plaintiff's counsel actually said the relief is left open. And that leaves the division in this very difficult position of shifting sands, of trying to figure out what it is they're really responding to. What is it really that the plaintiffs are asking them to do? And we respond to one thing, we say, well, we don't think we can do this. And then they say, well, how about this? And how about this? And we've got new hypotheticals even being generated now at oral argument. And that kind of instability, I think we all would have been in a much better position to be talking about what's the relief, how does this work, if we were talking about it in a calm manner in May and not in a rushed way, in late September, early October.
All right. I'll go ahead and let you get started. I may jump in with some other questions, though.
Of course. I have one more piece of information for you that you requested about whether voter email addresses are maintained in the voter database. My understanding is the answer to that is no.
Okay. Thank you very much for checking.
Of course. Your Honor, this is, as the plaintiffs have discussed, an as-applied constitutionality challenge. And of course, that is one way that a plaintiff can challenge the constitutionality of a statute. But the argument in this case is so much more difficult because it's almost as though the plaintiffs are arguing that a law could be constitutional one week when the case counts are low and then becomes unconstitutional next week when they go up, but then we get them back under control and it's constitutional again. And I think an essential part of this as applied constitutionality argument is that the constitutionality in their view depends in part on decisions that the plaintiffs themselves make. As you identified, Your Honor, it's unknown whether the plaintiffs will or will not decide to vote in the November election. And as you also identified, Your Honor, Arctic Village or other communities could make exceptions to their quarantine in order to allow for some ballot witnessing with safe practices. So the idea that a law could be unconstitutional because Arctic Village decides to structure its quarantine one way, but then could be constitutional if it was structured another way, and that decision lies solely with the plaintiff, with Arctic Village, is an untenable standard to which to hold the division of elections. And the other point that I'd like to make here that you very correctly pointed out, Your Honor, is that the plaintiffs did vote. The individual plaintiffs did vote in the primary and used CDC recommended guidance when doing so. And with regards to the communities with lockdown, the defendants presented evidence specific to the many efforts that the division and the lieutenant governor's office went to ensure that voting could still take place, even in communities like Arctic Village that had a quarantine or a shutdown at the time of the primary election. So in fact, the facts before you show that the division and individual communities were able to figure this out and find a way to make an exception or move a polling place or take down a barricade in order to enable voting on the primary election day. And it's purely speculative that kind of, that kind of thing won't work in the general. In fact, a more reasonable expectation is something similar would happen.
I do have a question about that, Ms. Harrison. I think I understand what you're saying. It's that, for example, Arctic Village could modify the lockdown rules and do sort of what they did in the primary. That could accommodate the witnessing. That's what you're saying, correct?
Yes.
Okay. What that doesn't address to me is what about the people that live in that community that even if they had access to a witness, don't want to have a witness signature because of their own vulnerabilities to COVID. I don't think it answers that question. It almost assumes that they, if given the chance, do want to do the witness requirement or would be comfortable doing it, but that isn't necessarily the case, is it?
Well, my understanding is that the situation of those voters that you're describing is the same as the situation of the individual voters who did provide affidavits. I think what I'm addressing here is this separate burden that the plaintiff has identified of you'd have to break quarantine. So I think that the burden when we're talking about just the individual voter, whether they live in Arctic Village or in Anchorage, of having to have this very brief interpersonal contact in order to have their ballot witnessed, I don't know that that's any different if we're just looking at that without the quarantine element for a person in a rural area versus a person in a larger community.
Okay.
And I would like to say something about that that topic of the witnessing. You know, the plaintiffs did have their ballots witnessed for the primary, and they used the CDC recommended precautions when doing so. In fact, the CDC recommended precautions are very amenable to the act of having your ballot witnessed. It can be done masked. It can be done remaining 6 feet apart. It can be done outside even. There's nothing about the witnessing requirement that would require people to forego those standard precautions that the CDC has recommended for these types of interpersonal interactions. So the burden of the witnessing requirement should not be considered severe in the dramatic sense of a life-risking activity. It is possible, and in fact, the plaintiffs did do it within those infection preventative standards. I'd like to also speak for a moment, Your Honor, about the case of Merrill v. Alabama, which was just cited by the plaintiffs. It's very important, Your Honor. You'll see when you read that case, I know it just came across your desk very recently. Alabama requires 2 witnesses. And that was important in that court's analysis. In fact, a number, if not all of the plaintiffs would have had access to 1 witness. So I would just highlight that to read that case with that eye. What's the difference between 1 and 2? And of course, Merrill v. Alabama is the case that was a prior injunction was stayed by the United States Supreme Court. This decision was issued yesterday. I expect it will go forward on an appellate track, and it'll be very interesting to see if the Supreme Court weighs in again on this new injunction. The Fourth Circuit cases as well, Your Honor, that were in the supplemental briefing today, I believe that a petition for stay was submitted to Justice Roberts earlier this afternoon. So those are also still very much in play.
Can I ask you a question? Oh, you go ahead if you were still talking about the cases.
No, I'll submit it in the supplemental briefing. There's one more case that was not in the supplemental briefing that's come out since the briefing was filed, but please ask me your question.
Okay, sounds good. I'm trying to understand, and if you've explained it in the briefing, I appreciate it, but I maybe am not fully grasping it. I'm trying to understand the mechanics of the witness requirement. So I have some specific questions about that. So as I understand it, an absentee voter can take their ballot, fill out their ballot, and then put it in the envelope, the return envelope. And one option is to go to a notary, correct? One option is to go to a notary?
That's right.
Okay. Do they have to put the ballot inside of the envelope in front of the notary, or do they simply have to have the notary notarize their signature on the outside of the envelope?
I believe, and I'll check the statute, but I believe that the witness is expected to observe the voter placing the ballot in the envelope. But let me just pull up the statute for you here, Your Honor.
Thank you.
Upon receipt of an absentee ballot by mail, the voter, in the presence of a notary public or other person, may proceed to mark the ballot in secret, place the ballot in the secrecy sleeve, place the secrecy sleeve in the envelope provided, and to sign the certificate in the presence of the official listed in the subsection. So my understanding is the expectation is that the witness will observe the person placing the ballot in the envelope. And that,
Actually,
Your Honor, that citation is 15-20-081.
Okay. And notaries require identification, correct?
I believe so, yes.
Okay. So in that situation, the voter is actually, the identity is confirmed in a way, I think, because the notary is requiring identification.
Yes, Your Honor.
Does that sound about right to you?
Yes.
All right. If the voter takes the option of going to somebody who's qualified by law to basically administer oaths, is there identification produced in that situation?
I don't know, Your Honor. I don't know whether when people were doing this before, postal officers, if they would have required identification.
Are there the same requirements about basically filling out the ballot, placing it in the envelope in front of the person who's authorized by law to administer oaths?
Yes, I believe the process is the same, whether it's a notary or another person.
Okay. And if it's a witness 18 years or older, are they required to watch the person complete the ballot, put it in the envelope, and sign?
That's less clear. The statute does say that they will witness the voter signing the envelope. And I am looking now at the envelope, and it says you have your signature witnessed.
When I looked at the envelope, it didn't seem to require that the witness 18 years or older actually watch the person place the ballot in the envelope. It just seemed to be sign the envelope saying that you saw the other person sign the envelope, the voter.
Yes, that is what the envelope looks like to me too, Your Honor.
Okay. And the reason I'm asking that question is there's no process of identification, at least with that option under the witness requirement. In other words, the witness is not performing the function of confirming that the voter is in fact the voter who's submitting the ballot, correct?
Officially, that's correct, but I would point out that in most circumstances, the person you get to witness your ballot is somebody you know. In most cases, people are having their ballots witnessed by friends or family members or neighbors. Even if the plaintiffs talk about having some contact with others, for example, a pharmacist picking up a prescription or someone delivering groceries. That's the kind of person you could ask to be a witness. You might naturally do that. And they know who you are. The pharmacist is filling your prescription. They have your information. The grocery delivery person knows your name and address because they're delivering groceries. So I think in actual practice, for the most part, witnesses know the person for whom they are signing.
I guess that leads to, I'm trying to understand very specifically how it is that the witness requirement prevents voter fraud. So for example, if you're saying, it could be your friend or your relative, that's signing in the capacity of a witness 18 years or older, I just don't understand how the requirement truly prevents fraud. So if you could explain that to me and help me understand, I'd be grateful.
Yeah, of course. So there's the element of identification, which we were talking about, but there's also the element of I saw this person sign this envelope on this date, verifying the date, and sealing it up. And so that's another piece of verification there. When was it done? And the same person who signed it is the one who sealed the ballot in there. But I think there's the deterrent effect as well, Your Honor, that you have to consider. The deterrent against the the crime of opportunity, perhaps, or the person who isn't really taking this seriously enough. Something that the legislature talked about a lot, if you listen to the 2005 recordings, Your Honor, from the legislative history when they changed from 2 witnesses to 1, something that they talk about is wanting to make absentee voting more like in-person voting, wanting it to be clear that this is an official act in the same way that in-person voting is, and to give it that weight, that imprimatur of an official action that comes with having it witnessed. And that they wanted it to be very different experience from, I got a survey in the mail and I'm going to fill it out. And so for a person who might think, oh, I know how my wife wants to vote this. I don't need to bother her with this. I'll just fill it out and send it back for her, right? The witnessing requirement causes that person to pause and realize perhaps, oh, this isn't quite that informal an affair. So that's sort of on the front end, the prevention of fraud and deterrence. But the legislature also talked about the back end and talked about detection of fraud afterwards. And I remember one legislator saying, it's a tool. It's a tool that the division has. And we have this experience that's in the record, the affidavits about the recent absentee voter fraud issues in 2014 and 2018. And you can see there that the division was very astute and detail-oriented in its detection of those issues. And so even, a fraudster might leave some clues in the fraudulent execution of the witnessing requirement that the Division of Elections might be able to pick up on.
But has the witness requirement ever been a part of detecting fraud? Has that ever been helpful in detecting voter fraud?
Of course, I can't say whether it ever has or has not been. I think in recent memory, it has not been part of it, but we've had it for such a long time. I certainly can't say it has never been.
And you are at 20 minutes, but I asked you a few questions, and I think I might have a couple more, so I'd like to add a little bit of time, and then I'll give you a little bit of leeway, Ms. Landreth, because I'm going over a bit.
Yes, thank you. Your Honor, I'm sorry, did you have another question for me now?
No, go ahead. I do have more, but I'm not ready quite yet, so go ahead.
Okay, well, I'd just like to talk briefly about the practicalities, if I could, before I run out of time.
Sure.
I mentioned earlier, how difficult it is to get airtime right now. And of course, if the division were ordered to do any mailings, that is going to take a little bit of time to design it and to get it printed and get it out to voters. So the division feels strongly that if it is going to have to undertake a project such as you outlined, Your Honor, in your order on the temporary restraining order, it needs to start doing that absolutely as quickly as possible, and it would like to get the chance of appellate review before it dives into such a project. So, Your Honor, if it is your intention to issue a preliminary injunction along those lines requiring a significant effort by the division to educate voters, division respectfully requests that you would issue that order no later than tomorrow, and that you would immediately stay that order pending an appeal to give the division the chance to get this up to the Alaska Supreme Court, if possible, on an expedited petition for review next week. So that's the practicality issue to address, is that if you do intend to issue such an order, to please do it as soon as possible, before tomorrow, if possible, and to stay it pending any appeal. Because of course, we do have the situation from other states that we've learned about where a trial court stayed this requirement, or a trial court enjoined this requirement, then an appellate court stayed the injunction a day later, and in the interim, some voters may have sent in unwitnessed ballots that weren't counted, and the division's very concerned about a situation like that here.
And I can understand that. Of course, it's a lot of information, and they're important issues, and it's unfortunate there isn't more time to truly address them at a deeper level, if you understand what I'm saying. But I understand your point.
Your Honor, a quick comment on the equal protection argument, which hasn't really been addressed. I just wanted to point out that the plaintiffs, for the first time in their reply brief, suggest that this might be what's called a disparate impact case. I'm sure, Your Honor, when you read those disparate impact cases, you will see those are cases involving discriminatory intent. And of course, there's no allegation of discriminatory intent here. It wouldn't really make sense in the context. So I think the addition of suggesting this is a discriminatory intent case does not change the analysis. It's a facially valid statute.
All right. One more question I think I have, and this is just sort of a detail. I'm just trying to understand this process. So if you order or request an absentee ballot by electronic means, how do you send that back if you're that voter? There's not that envelope that you submitted with the briefing. Do they just use a normal envelope? I'm trying to understand where the witness signs if you're electronic.
So you print out the materials. You have to have access to a printer in order to get the electronic delivery. And then you can either return it by mail, or I believe there's an option to return it by fax. But those printed materials do have the voter affidavit and the witnessing segment on them.
Okay, thank you. I think those are all my questions for you. Do you want just a minute to sum up, because I've taken a little bit more of your time?
Thank you, Your Honor. To sum up, I would return you, Your Honor, to that mission statement of the Division of Elections to ensure public confidence in the electoral process by administering voter registration and elections with the highest level of professional standards, integrity, security, accuracy, and fairness. That type of a mission requires balancing a number of different goals and a number of different interests, and the legislature has conducted that balancing and determined that a witnessing requirement is an appropriate way to advance those interests, to safeguard against voter fraud, to enhance the legitimacy of the absentee voting process in the eyes of the public and the voters, to put the division in this terribly awkward situation, very late, of having to try to change the rules, undermines that important goal. This court should deny the motion for a preliminary injunction. Thank you, Your Honor.
Thank you so much. All right, Ms. Landreth, you can take a couple extra minutes because of the time that I allowed the other side to go over. Thank you.
Thank you, Your Honor. I'd like to first point the court to, and this may seem disjointed because I'm going to run through a few points in my reply here, is that page 14 of our reply brief, there's a quote at the beginning of, footnote 48 there that is particularly relevant. In ordinary times, it says Virginia's witness signature requirement may not be a significant burden on the right to vote, but these are not ordinary times, end quote. That is what renders this a burden that it might not otherwise be. Second point, the data that you discussed is the CDC linked race data. If you go to the CDC website and look for data by race, it will take you to that exact dashboard linked in our brief. And there really isn't time for peer review. That's going to be your best source of data. Second, or third, I should say, if we had filed in May, let's be honest, the division was still going to say it's too late. And the reason I say that is because I believe in the opposition to the TRO, Ms. Funumia, I said the first batch of absentee ballot envelopes were printed in April. So this exact same argument would be happening, only they would be saying, we already printed the first batch. We can't have the batches look different. You're asking us to start over. So let's be clear about that. Number 4, they've never been able to describe how the witness requirement makes any kind of difference, and here conceded they really haven't ever used it for fraud in their memory. Why are they going to great lengths to preserve this? They say they went to great lengths to help Arctic Village try and vote. Well, I respectfully suggest the best lengths that they could go to would be to say, here's your envelopes, no need to get a witness signature this time. Next, and I think one of the things they reference the shifting sands and requirements, as I explained, the intention was for the division to say what it could do. And an important fact that the court needs to take a look back at is what was attached to the complaint when we notified the defendants on August 31st that there was a serious problem. They just said no. on September 4th. No, we're not going to do that. We're not bending the rules for you or anyone. That would have been the time frame to say, we can't reprint anything, but here's what we're willing to do, and this is it. And none of that ever happened. What happened was what you see here, which is just digging in the heels and saying no. And that's the purpose for that. We were trying to be accommodating, open-ended, what can we do, and nothing. Now let's be clear in terms of harms, really specific. Ms. Jones cannot vote again the way she did in August. It's not going to happen because the Postal Service is no longer allowed to do that. So there is a direct harm that we have no idea how that is going to be remedied. There's also, on a related point, absolutely no evidence that people generally know their witnesses. There was nothing before this court about that. The court also asked if the division maintains email addresses. I'm looking at an absentee ballot application online that asks for an email address. So I'm confused by the answer to that question. We would, of course, oppose, as she mentioned, a procedural issue requesting a stay, and find it ironic considering their concern about latches. If we want to let people know, we need to do that now, and they'd have to show some pretty significant harm to get a stay. And just two more points here, Your Honor, and then I'll close. We didn't get a chance to discuss a lot of the equal protection because I simply ran out of time, to be candid with the court, in the opening part of my statement. But this law clearly burdens one class of voters far more than others, and that's people, the same group that the defendants thankfully decided to protect by automatically sending them ballots. They recognize this is a very vulnerable group. And when you add race on top of that, the statistics become even worse. And our equal protection standard, of course, in the state of Alaska is different. It's a sliding scale, and fundamental rights like voting do receive strict scrutiny. So they really can't meet that standard in this case. And lastly, the state has mentioned a couple times, and their efforts are certainly appreciated in Arctic Village, make no mistake about that. What they describe is the incredible lengths they went to make sure that people there could vote. In Nunamikwa, which we cited, there were 10 people out of 200 that did it. That's not their usual voter turnout. But I think the problem here is that they are also going to incredible lengths in this case to force voters, the most vulnerable category, to expose themselves to COVID-19. And frankly, after this argument, I still don't understand why. I don't have anything further, Your Honor.
All right, thank you very much. I appreciate it. So Ms. Harrison was asking or indicating that the defendants would very much appreciate a decision. I think you indicated by tomorrow, Ms. Harrison. What I had planned to commit to was to give you all a decision on Monday at 11:30. That would give me time to digest the new cases that you all are bringing my attention to, or the new developments, I guess I should say, and to have a little bit more time to digest the arguments. So I do want to ask Ms. Harrison, if that is when I'm able to give you a decision. It's one more business day, and I don't know if you have anything you want to say about that delay based on what you requested and what I think I'm able to do.
Your Honor, of course, you must do what you are able to do. I just wanted to make sure you were aware of the concerns that the division is having about any effort to undertake a significant voter education effort at this time. There are practical concerns there too. So I just want to make sure that was on the record and you have that information.
All right, thank you. And I am, of course, wanting to issue a decision as quickly as I can. But again, I want to have time to think this through, given the time constraints. So actually, I misspoke. It wouldn't be 11:30. I would be able to put a decision on record. I plan to anyway, absent something extraordinary, on Monday, October 5th at 12:30. And I'm assuming that you all would like to listen, and I could put that on, we could calendar that and put it on court view. Is that what you would like to see? Ms. Harrison, I'll start with you.
Yes, Your Honor, we would of course like to listen to a decision on the record. Thank you.
Okay, just checking. And same question for you, Ms. Landreth, the timing and how you would like me to deliver the decision.
Yes, that's fine. Thank you, Your Honor.
Okay, my only caveat to that is if I'm able to issue a written decision, I wouldn't need to put it on record orally. In some ways, I would prefer to do that, but I'm just going to see how my time constraints work. All right, so I'm taking those two motions under advisement for just a couple of days, and I think that's all we need to do today, or we plan to do today, but let me ask Ms. Landreth if there's anything else we need to discuss.
I don't think so, Your Honor. Thank you.
Okay, Ms. Harrison, anything else?
No, Your Honor. Thank you for your time.
All right, thank you so much, and thank you for the briefing. It was excellent, and the argument was excellent. I really appreciate it. All right, we'll be off record. Thank you for joining me today.